Recording in progress.
Good morning and welcome to today's press conference. I'm Stephanie Levitz with the Globe and Mail. I will be moderating. I have a few important preventative measures to share for our panelists here. If you're going to be using your headpiece, please make sure you keep it away from the microphone at all times. When you're not using it, please place it face down. There should be a little tab on the table for that purpose. It's to prevent audio injuries for our interpreters. And with that, I will open the floor to you.
You want to put it on?
Hello, bonjour. Merci d'avoir pris le temps d'assister à notre événement médiatique concernant l'un des problèmes les plus importants en matière de droits et de droits de la personne au Canada d'aujourd'hui. My name is Slava Balan, and I'm the Executive Director of the International Commission of Jurists Canada. Together with the three esteemed speakers in front of us today, we would like to present the key points from a major pan-Canadian event which took place on November 29th in three cities of Canada: Ottawa, Montreal, Edmonton, and online. The one-day-long event, titled A Call to Action, Fundamental Rights and the Notwithstanding Clause, was hosted by a group of organizations from across Canada, including the International Commission of Jurists Canada, La Faculté de Droit, Université de Montréal, the Center for Constitutional Studies at the University of Alberta, the University of Ottawa's Faculty of Law, and the U-Ottawa Professional Development Institute. The aim of the event was to bring together a diverse group of scholars, lawyers, journalists, and others to discuss the challenges posed by the evolving practice around the Notwithstanding Clause, formerly known as Section 33 of the Canadian Charter of Rights and Freedoms. This provision of the Charter, which allows Canada's federal and provincial governments to derogate from some of the key provisions of the Charter human rights commitments, has been invoked with unusual frequency in the last half-decade, ending a period of its relative dormancy. In light of this shift from the clause's dormancy to activity, the 29th November event addressed a set of insistent questions about how political and legal actors might navigate the changing landscape of rights protection in Canada, including questions about the types of legal arguments and political action that might be deployed in response to more concerning uses of Section 33 in the coming months and years. The speakers today are Senator Peter Hader, Professor Earl Mendes, University of Ottawa Faculty of Law and President of the International Commission of Jurists Canada, and Professor Stéphane Bollac, Université de Montréal, Faculté de Droit. Following short presentations by the speakers, there will be time to address questions. Please.
Thank you very much. One of the things I want to start with is by presenting the views from the University of Alberta. And one of the reasons why it was critical that we have the University of Alberta presenting their views is that they were keen to present one of the architects of Section 33, who is often not really discussed very much in the media, with all the discussion on Section 33. I'm talking about Premier Lougheed, who was there at the creation of Section 33 when he was in favor of it, but his strong position, and he basically made this clear in his presentations to the University of Alberta in the 1980s. I was there as a former law professor from the University of Alberta, when he basically stated that even though he was in favor, he was very insistent there should be political accountability for any use of Section 33. And the way he presented that was that, first of all, he was strongly in favor of not using a preemptive use of Section 33, which means that you would be preempting the judicial branch to making its view on whether or not a Section 33 clause is justified. And he basically felt that that was a precondition of him, a conservative premier, from essentially accepting the notwithstanding clause. He also went on to say that, in his view, this notion of political accountability meant that there should be a majority vote in the legislature before it is used. Now, what's really interesting, that his views actually carried through into the public in Alberta. And keeping in mind that he was a conservative premier and subsequent premiers were conservative, like Conservative Ralph Klein, who used Section 33, but because of the backlash from the media, political society, on two occasions, firstly dealing with the compensation for sterilization, and secondly dealing with his attempt to basically prevent the move towards same-sex marriage, the backlash led him to back off on that. So what the University of Alberta did in this presentation was to present, if you like, the views of a conservative premier. And given the fact that we have the potential for a future conservative prime minister who says he or she will use the clause very much, gives you an indication that the creation of Section 33 was very much driven by a conservative view that there should be political accountability for the use of such a clause, which meant to not have the preemption use of the clause, and secondly, to have at least a majority view of it. So this was the views of our colleagues at the University of Alberta, who was very keen to present that view of the origins from Alberta of Section 33. So moving on then to the views of my own university's presentations on that, we built on that to point out that where the most recent invocations of Section 33 on 3 occasions by Premier Ford really showed that what was at stake was not really the sovereignty of legislatures to override judicial decisions which may be overstretching the views of the judiciary, but in fact what was happening in effect was an autocratic intent by the executive on 3 occasions. Firstly, when dealing, for example, with the use of the Section 33 clause in terms of seizing down or scaling down the wards in Toronto from 47 to 35, when because a Superior Court judge basically said, you can't do that, it's in violation of the Charter, Premier Ford immediately brought in Section 33. Now, eventually, that was allowed on appeal, and ultimately in the Supreme Court of Canada, that too was allowed. But I want to stress what happened in the Supreme Court of Canada was very significant, that even though a majority allowed the use of Section 33, a strong dissent said that there were unwritten principles of the Constitution which would invalidate that legislation. And the ones that they stressed, most important, was the democracy principle, the rule of law principle, and the protection of minorities principle. So that gives you an indication that in the Supreme Court of Canada, there are potential limits to how the clause should be used. Again, to go back to Premier Lougheed's view, there has to be some accountability for the use, excessive use of the clause. Nevertheless, Premier Ford went on to use it twice again. One, again, in terms of trying to limit the advertising by his chief adversary, the unions, by extending the period by which they could not give compensation. Yet again, that too went all the way up to the Supreme Court of Canada. As an intervener in the Supreme Court of Canada, again, the International Commission of Jurists tried to stress that because what was at stake in that case was the Section 3 right, the democracy right, was that there should be a very strong interpretation by the court to stop the use of the Section 33 to undermine non-derogable rights. We are waiting for that decision, and we hope that the Supreme Court of Canada will give you some indication that they too will have some concerns yet again with Section 33. And the final one, which is obviously one which we had in some respects, not so much the sovereignty of the legislature being in play, but the sovereignty of the people. When again Ford used Section 33 to stop a potential strike by the lowest paid workers in the education sector. And he threatened to use of it and did use it, but because the workers and a very strong majority of Ontario's population basically had a backlash against that, he finally backed off. So what does all this say? It basically says that, yet again, the most recent use of Section 33 is a fundamental lack of political accountability, fundamental lack of the promise by a conservative Premier Lougheed that there should always be checks on the excessive use, such as, for example, preventing the preemptive use, and secondly, at least giving an indication for the public to have some say in the use of a clause which potentially can undermine still the most important constitutional document that the vast majority of Canadians still consider as a critical part of the Canadian Constitution, the Canadian Charter of Rights and Freedoms. So in the end, we in Ottawa basically stressed that going back to Premier Lougheed's view that there should be political accountability and safeguards, we are suggesting that in addition to the points we made, that we teamed up with the Canadian Bar Association. And they, together with us, and some of us working with the Canadian Bar Association, presented a letter to Minister Virani, the Justice Minister, to suggest that there should be critical guidelines in the future use of Section 33. And let me spell them out. Firstly, there again should be a prevention of the use of the preemptive clause. Secondly, there should be a majority vote. Thirdly, there should be a large amount of public discussion, possibly through the use of a preamble, which allows more discussion in the legislature to therefore give some semblance to the idea of legislative sovereignty as opposed to executive autocratic responsibility. And then finally, like the others, we too agree that there should be some way in which there should be, for example, a charter compliance review by the Department of Justice before there is a formal presenting of a Section 33 clause before Parliament. So I'll leave it at that, and I'll pass it on to my colleague who was in charge of the University of Montreal's presentations.
Merci, Harold. Good morning to all. Alors, l'événement tripartite, Université de Montréal, Ottawa et Edmonton, était sous le thème de l'appel à l'action, pour élargir les débats et essentiellement essayer d'interpeller la société civile pour qu'elle soit plus intéressée à ces dossiers qui sont trop souvent résumés en une opposition simpliste entre la volonté populaire et les chartes, comme on aime amicalement ou moins les appeler, les résumer au Québec et ailleurs au pays. Le panel de Montréal était sous le thème du retour aux sources, parce que c'est sans doute la première chose à bien comprendre quand on s'intéresse à la clause de dérogation. Ce dont il est question, ce sont les libertés fondamentales, ce qui, depuis belle lurette, et on peut rappeler la Déclaration universelle des droits de l'homme, ce qui est considéré comme étant inaliénable et inhérent à la personne humaine. Alors, on a des instruments au pays. Au Québec, la Charte québécoise. Au Canada, cet instrument supralégislatif, la Charte canadienne. Mais il faut se rappeler qu'au-delà des textes, ce sont des éléments qui sont inhérents et inaliénables à la personne humaine. La décision Ford de 1988, très malheureusement, est parfois considérée, surtout dans la province de Québec, mais ailleurs au pays, comme étant intouchable. Comme si une seule décision pouvait décider, faire le tour de tous les aspects de la question de la clause de dérogation. Or, cet aspect est vraiment en porte-à-faux avec ce qui se passe habituellement par rapport à des questions surtout complexes touchant la Charte canadienne des droits et libertés. Autrement dit, en matière de charte sous la Charte canadienne, en matière de charte sous la Charte canadienne et sous la Charte québécoise, il y a habituellement une série de décisions qui viennent articuler les tests applicables. Or, ce que nous croyons, est essentiel dans le contexte actuel d'une recrudescence des utilisations de des clauses de dérogation, c'est de venir compléter. Pas renverser ou changer radicalement la façon de comprendre l'article 33 de la Charte canadienne et l'article 52 de la Charte québécoise, mais bien de raffiner les tests et, comme mon collègue Mendez le suggérait, de reconsidérer la question de savoir si le rôle des tribunaux en tant que gardiens de la primauté du droit, gardien de la Constitution canadienne, de la légalité dans le pays, devrait être plus exigeant et aller au-delà des simples aspects de forme qui ont été énoncés dans l'affaire Ford de 1988. Je le répète, ce n'est pas une question de renverser Ford, c'est une question de compléter le schème d'analyse en matière de dérogation sous la Charte canadienne et la Charte québécoise. À notre sens, une reconsidération de l'interprétation de 33 doit être au diapason avec les ajustements majeurs depuis 2020 en matière de méthodologie d'interprétation de la Charte canadienne, avec une trilogie des affaires Poulain, Québec Inc. et Cité de Toronto, qui viennent réhabiliter le texte, mais qui maintient le focus sur la question de savoir quel est l'objectif. L'objectif de la disposition, l'objectif de l'article 33 ici. Et à cet égard, quand on considère l'article 33 dans son contexte, eu égard à ce qu'il veut accomplir, et surtout en prenant en considération, à la lumière de l'instrument supralégislatif qu'est la Charte canadienne, on doit comprendre 33 comme étant une mesure d'exception. L'exception qui confirme la règle étant la protection supralégislative des droits humains au pays. Alors, quand on garde cela en tête, ça vient valider une interprétation qui va maintenir le rôle de gardien de la primauté du droit, de la légalité, de la constitutionnalité. Donc, les cours devraient intervenir, sont justifiés d'intervenir et d'exiger plus que ce que suggère jusqu'à maintenant la jurisprudence au pays. À cet égard, deux derniers points. Le droit international valide une telle interprétation. On le sait, ce n'est pas juste cliché de parler de mondialisation, y compris du droit constitutionnel, mais l'utilisation, le recours au droit international est de plus en plus fréquent et justifié en interprétation constitutionnelle, et ça devrait être le cas pour la réinterprétation de l'article 33, eu égard principalement à deux normes, celle de l'accès à la justice et du droit, d'une part, et d'autre part, le droit à un redressement. Parce que c'est ça qu'on doit comprendre de l'article 33, c'est que si on l'invoque sans exigence substantielle quelconque, on met frein à la possibilité pour les Canadiens et les Canadiennes d'avoir accès à la justice lorsqu'il y a une violation des libertés fondamentales, ce qui aussi, en bout d'analyse, empêche d'avoir un redressement judiciaire. Et dernier point, j'aimerais souligner que dans le contexte contemporain où les considérations, les enjeux liés aux droits autochtones et à l'autochtonie plus généralement en matière de droit constitutionnel, j'aimerais souligner qu'un récent arrêt de la Cour suprême du Canada de l'été 2024 dans l'affaire Vuntut-Gwitchin semble valider l'idée que les tribunaux devraient être impliqués dans les décisions qui peuvent mener à une limitation, à une restriction, à une gamme de droits et libertés. Dans cette affaire-là, on a interprété l'article 25 précisément de la Charte canadienne des droits et libertés qui protège, qui joue le rôle de bouclier afin de protéger les intérêts et les droits autochtones. Et dans cette affaire-là, la Cour suprême du Canada clairement a gardé ce rôle de gardien de la validité constitutionnelle pour protéger une des valeurs les plus fondamentales dans la façon de gouverner dans une démocratie constitutionnelle comme le Canada, et c'est ce principe de la primauté du droit, en anglais, the rule of law, qui est fondamentalement ce qui est de la responsabilité des tribunaux qui devrait continuer à être leur mission constitutionnelle. Alors voilà, résumé, les takeaways, comme on dit en anglais, les principaux points découlant du panel de l'Université de Montréal. Merci.
Thank you very much. Just before I hand over to Senator Harder, we were very pleased that Senator Harder agreed to come and present his views at the University of Ottawa's event. And for that, I'd like to pass over to Senator Harder to give what he said at the conference, which I think was very much strongly supported by everyone else from the three universities.
Thank you very much, Professor. As has been made clear, the notwithstanding clause has never been used at the federal level in 42 years. And yet, last spring, there was musings from the leader of the opposition at a speech that he gave before some policemen that he would consider invoking the notwithstanding clause in federal legislation. I was very disturbed by that and thought that there would be, frankly, a public reaction of some note, both politically and from social media, and was disappointed that it seemed to go unnoticed, almost because there has been a normalization of the practice based on the provincial experience that has been referenced. So in May of this year, May 23rd, I tabled a motion in the Senate outlining how the Senate should react should a notwithstanding clause bill be introduced. I spoke to that motion in September 24th, and I'd like to just highlight how I believe a Senate should act, and frankly, how I wish a House of Commons would act, because it is in many senses on this matter a chamber that ought to consider the Charter of Rights and Freedoms in a very focused fashion. So here are the principles. One, there would be no preemptive use. That has been described already in this panel, and I won't detail it. Second, that the Minister of Justice, as the Minister of Justice does for all bills now, table a charter statement, which would very clearly have to indicate what are the charter implications of the bill being proposed. Third, a commitment by the government that there would be no time allocation used in the consideration of this bill in the Senate, and I hope in this House of Commons. And four, that there would be, as a result of that, appropriate hearings to hear from experts and those affected most by the proposed bill. This would ensure that there was an appropriate dialogue and public engagement, because as the founders of the notwithstanding clause felt, that this should be a very rarely used instrument that should not undermine the Charter's provisions. A lot of talk in the last while about parliamentary supremacy versus judicial supremacy. And the founders of the notwithstanding clause very much were on the parliamentary supremacy side with a price. In other words, there was the 5-year limit and the engagement with an electorate. I would like to suggest that with the approach I'm outlining, that we would be reinforcing neither parliamentary nor judicial supremacy, but constitutional supremacy, because that, after all, is what this is about. How do you engage in a dialogue with Canadians when they're rights are being removed by the very government. And I worry, frankly, about populist authoritarian governments undermining the whole charter, which so many Canadians view as a defining instrument of what it is to be Canadian. Thank you.
Thank you very much. And we're open to questions now from the media.
Thank you. I'll ask our participants who are online to please use the raised hand function on Zoom if you have a question. I don't see any online, so I'm going to use my moderator's privilege to ask one, if that's okay. When we talk about accountability for the use of the notwithstanding clause, doesn't that ultimately belong in the hands of voters? I mean, Saskatchewan, the government there was re-elected. Doug Ford's been re-elected. Bill 21 is very popular amongst Quebec voters. Shouldn't that be the ultimate check against for voters to have the say in whether they approve of this or not?
Actually, go ahead. Yes. Yeah,
I'm
go ahead.
prepared to say some stuff on that. We live in a democracy. Of course, voters have an important role to play, and it was designed in the instrument itself. My concern is that the use of the notwithstanding clause is politically achievable when you're dealing with the least able to defend themselves in the court system, and that is a worry. And I think it's to the credit of governments of all parties at the federal level not to have contemplated the use of the notwithstanding clause, even in the face of the rejection of legislation that they otherwise would have favored. So I understand your comment about the discipline of the electorate, and it's provided for. But if you are concerned about populism, running roughshod over individual rights, particularly of those who are less able to defend themselves, I think we've got a real serious problem.
And can I add to that? One of the things that is often forgotten is that the reason why we have a Charter of Rights and Freedoms was that after the end of the Second World War, there was an agreement by Canadians coast to coast to coast that we had to show that we are in agreement with what was being developed at the international stage, which was the Universal Declaration of Human Rights. Often forgotten that a Canadian was one of the drafters of the Universal Declaration of Human Rights, John Humphreys, a former professor at McGill University who became the director of the UN Human Rights Commission. And Pierre Elliott Trudeau basically picked up on this amazing feat by a Canadian, but by the whole world, to have a document which would basically say, in a democracy where you are committed to these fundamental rights, the views of majority cannot always prevail. That ultimately there has to be ways in which you can have rights which are protected by some means whatsoever. We decided in 1982 to have a Bill of Rights which then would be protected primarily by the judiciary. Yes, we decided that there would be legislative supremacy through the use of the Section 33 clause. But before that would happen, there would be some form of accountability, as Premier Lougheed said, should be in place, such as not having the preemptive clause to allow the courts to rule on it, and secondly, to give some indication that within the legislature itself, you're talking about voters. Well, what about the majority of the legislature itself to have a vote in the erasing of the rights? And then finally, I can point out to you one thing which happened with Premier Ford's use of the notwithstanding clause, when he basically was going to use the clause to stop the strike by the lowest paid education workers in Ontario. Think about what would happen if he had gone ahead with this. That essentially, by not giving them the right, yes, ultimately he may have essentially been re-elected, but what would happen to those voters, those workers? What sort of democracy would they say is happening in Ontario when their rights have been completely erased? So I'm talking about voters, yes, but think about which voters which would be susceptible to the autocratic use of Section 33. Do you want to add anything?
Oui, je vais ajouter. Bon, on est prof d'université, alors on est là pour donner un peu de perspective. On peut reculer, évidemment, l'héritage de l'après-guerre, Seconde Guerre mondiale, avec les instruments dont celui auquel je faisais référence tantôt, la Déclaration universelle, qui a été par la suite articulé plus en détail pour protéger justement ce qui, je le répète, est inhérent et inaliénable à la personne humaine. Il faut arrêter de penser, cela dit avec égard, pour les gens qui semblent le suggérer, que les droits humains, ce sont des cadeaux, ce sont des choses que les représentants de la population, à travers la structure étatique, donnent aux justiciables. Non, non. On a ces instruments pour valider, pour confirmer, avec une clause échappatoire qui est l'article, la disposition de dérogation, l'article 33, l'article 52, 33 de la Charte canadienne, 52 de la Charte québécoise. Mais j'aimerais retourner même avant la Seconde Guerre mondiale pour rappeler que la paix de Westphalie de 1648, qui a mis fin à la guerre des 30 ans, qui est vue généralement non seulement comme étant le berceau de notre système de relations et de droit international, mais qui est vu aussi, ces deux traités de Münster et Osnabrück, comme étant la première manifestation d'un raisonnement en termes de documents constitutionnels. Or, la paix de Westphalie, une des choses qu'elle souhaitait accomplir, c'est protéger les minorités religieuses dans les principautés dont le prince adhérait à une religion différente. C'est ça le constitutionnalisme. Ça date pas de 1982 ou de Pierre Elliott Trudeau. Ça date même de bien avant la Déclaration universelle des droits de l'homme. C'est que l'histoire de l'humanité démontre que quand on laisse, puis je rejoins votre question, le soin à la majorité de décider de la protection des groupes minoritaires, ça ne fonctionne pas. Il faut avoir une façon qui est équilibrée parce qu'on veut ni une extrême ni l'autre, mais on veut trouver un équilibre, ce qui, en 1982, avait, pour les gens qui négociaient, pensé que l'article 33 contribuerait à un tel équilibre. Là, toutefois, qu'est-ce qu'on voit 45 ans et plus tard? C'est que l'équilibre est brisé. Cette utilisation excessive de l'article 33, non seulement dans ma province, au Québec, en invoquant des liens avec l'identité québécoise afin d'avoir l'appui de la population, justement. Et dans d'autres provinces, on a entendu beaucoup parler de l'Ontario, mais c'est ailleurs aussi au pays, ces utilisations ou évocations excessives de la clause de dérogation dans la Charte canadienne des droits et libertés de la personne, ça a le potentiel de court-circuiter ce qui fonctionne, somme toute, très bien depuis 1982. Et il faut revenir, on revient au thème, un appel à l'action pour revenir aux sources, revenir à un raisonnement qui rappelle et met à l'avant-scène que ce dont il est question, madame, ce sont les protections des libertés fondamentales. Ce qui est, vous allez me trouver fatigant, mais je vais le répéter une troisième fois, inhérent et inaliénable à la personne humaine. Ça, on devrait le rappeler au premier ministre Doug Ford et au premier ministre et son ministre de la Justice, un ancien doctorant de chez nous par ailleurs, Simon Jolin-Barrette et François Legault au Québec. Merci.
I think that is all the time we have for today. Thank you very much to everyone.
Thank you.
Recording stopped.